Welcome back, everyone. And buckle in because today's case is one of the most chaotic, emotionally charged, and downright unbelievable road rage incidents we've seen in a long time. This isn't just a simple, you cut me off moment. No, this spirals into a full-blown confrontation involving hair pulling, door yanking, a moving vehicle, and even one detail that had the entire courtroom raising eyebrows. We've got two defendants, Ortega and Torres, both young, both facing assault charges, both with very different energy levels in front of the judge. And as you'll soon see, the judge is absolutely done with the nonsense. He's stern, emotional, frustrated, and determined to send a message that Harris County will not tolerate violent road rage cases escalating into this kind of chaos. But the real twist, one defendant outright admits to the assault while still claiming the victims were the aggressors. Even though witnesses and video tell a completely different story, add in a sudden drug test order, questions about criminal history, emotional comments about family health, and a surprise second assault case. And this hearing quickly turns into a roller coaster. As we move through each moment, I'll break down the legal stakes, highlight contradictions, and help you make sense of the emotional clashes unfolding right in front of the judge. Let's dive in.
Are you Genevieve Ortega? Geneva Ortega. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Officers were dispatched to a road rage incident and spoke with two complaining witnesses who advised that the incident started at the gate of their apartment complex as they were trying to leave. The defendant's car was stopped in front of the gate and complaining witness one honked her horn so she can move her car out of the way. The complaining witness made a right turn to...
Hold on. Co-defendant. Are you Ms. Torres? Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You speak English, correct? Okay. So I think where we left off, you said that there was a defendant's car was by the front gate of apartment complex.
Yes, Your Honor.
Okay.
And the complaining witness one honked her horn so she can move the car out of the way. The complaining witness one made a right turn to go westbound on West Little York, and complaining witness one and co-defendant stopped at a red light. The co-defendant, Ms. Torres.
Pause for a moment, because what we're seeing here is exactly the type of road rage escalation that judges warn about constantly. Notice how the situation goes from a simple honk at an apartment gate straight into objects being thrown, cars braking aggressively, and someone yelling, "Pull over, let's fight." This is where the legal line gets crossed. A honk is not a crime. Even someone getting annoyed at a honk is not a crime. But intentionally braking to intimidate another driver, throwing things at their vehicle, inviting them to fight, that's where assault becomes a real possibility. The officer's summary shows a pattern: escalation, pursuit, confrontation, all confirming the mindset of intent. This is why probable cause becomes incredibly easy for a judge to justify in a case like this. And honestly, ask yourself, have you ever been that mad behind the wheel? Would you ever get out of the car to start a physical fight? Because this is how people end up seriously hurt or worse.
Co-defendant, Ms. Torres, started throwing things at her car. They went westbound on West Little and then made a right at Eldridge, and defendant Torres yelled, "Pull over, let's fight." The complaining witness two said that they continued going northbound on North Eldridge, and the defendant brake checked her several times before stopping in front of the complaining witnesses.
It's like something I see out of YouTube, man.
Defendant then got out of the passenger seat, walked up to the complaining witness one's vehicle, attempted to open the side door to remove her from the vehicle. Complaining witness two got out of the passenger seat to prevent defendant from opening the driver's side door. The defendant was able to open complaining witness's one door because when complaining witness two opened the door, it unlocked all of the doors. The defendant grabbed complaining witness 1, dragged her out of the vehicle by the hair, struck her with a closed fist towards her head, scratched her, and threw her in the dirt.
This is a
Complaining witness
critical moment. Ortega admits to the assault. That alone is huge, but then immediately tries to shift blame by saying the complaining witnesses were actually the aggressors. Legally, that strategy almost never works when both witnesses agree on the same series of events. There's physical injury, and most importantly, there's video evidence confirming she was the primary aggressor. Admissions can soften how the court views someone if they come with genuine accountability. But saying, yes, I did it, but they made me, that weakens credibility. Judges are extremely sensitive to deflection, especially when the violence involved pulling someone out of a car and throwing punches. And did you catch the judge's reaction a few seconds ago? That, like something I see out of YouTube, comment, that's not humor, that's frustration, and it signals how seriously he's taking this case. Would you believe Ortega's version after hearing all of that?
complaining witness
So
tried
who did that specific? Was that
defendant
Ortega or Torres?
Ortega. And then complaining witness tried to break up the fight, and while doing so, the defendant grabbed him by the genitals and would not let go. Both complaining witnesses felt pain/discomfort. Injuries were observed on the complaining witnesses, and the defendant, Ortega, admitted to the assault but said the complaining witnesses were the aggressors. Witness and video confirmed that the defendant was the aggressor. As far as
What about the
defendant number 2,
genitalia grab, Pavel? No one charged on that one?
I don't know. It's probably,
You know?
yeah, not as of right now.
Ladies, I'm going to find that there's probable cause to go forward with your case. Ms. Ortega, if I send you for a drug test right now, what are you going to test positive for?
Nothing.
I'm sending you for a drug test right now. You too, Ms. Torres. I expect you guys to come back. At that time, we'll talk about your lawyer. If you do not come back, I will set your bond extremely high. I'm done playing games. I will not stand for it. I'm going to do everything in my power to protect every single person of Harris County. Do you understand? If I find that you violate that, I will do that to you guys. And I will revoke your bond, make it extremely high. You understand? Who is driving in this caper?
is Ortega.
Ms. Ortega, do you have a Texas driver license?
I was
Actually,
not
let me,
I was driving.
Do you have a Texas driver license? I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case, not to be in possession of weapons. I'm sending you now for a test and then you must come back. Do you understand? Okay, take a seat for me. Okay, so we'll do the conditions now and then we can tell Tracy. Okay. Ms. Torres, you tested positive for marijuana. I am now making it a condition that you are not to smoke. I'm telling you that you will be tested 31 days from today. Guess what happens if you test positive? Right. You hold the keys to the jail cell. How old are you? How old are you?
19.
What do you do for a living?
I'm a bartender.
Where?
The Zone Sports Bar.
Did you graduate from high school? Like I said, you've been ordered not to consume alcohol, illegal drugs, unprescribed controlled medication. I will bring you back in 31 days to test you. How much money do you make a month?
Okay, like 1,000.
Okay, I will appoint your lawyer, but today's already 1 o'clock. It's too late. So what we'll do is I will give you an application. You can take it back with you. And the next time you come, you can give it back to us and we'll appoint your lawyer. You will get tested again. No more smoking. I will not accept any kind of explanation. I was in a car and other people were smoking. Someone gave me a gummy. I didn't know what it is. I don't care and I will not entertain excuses. Do not have any contact. And the problem is, Ms. Torres, is this is at 19. This is your second assault case. Why so angry?
This is where the tone of the hearing shifts dramatically. The judge stops being procedural and starts being personal because this isn't just about one assault. He's looking at the bigger pattern. A 19-year-old with a second assault case, substance issues, and clear anger control problems. Judges don't lecture for no reason. When he asks, why so angry? He's signaling that this behavior could eventually lead to something far worse. And he even mentions the possibility of an aggravated assault carrying up to 20 years. He's trying to get her to reflect, to understand that one moment of uncontrolled rage can destroy her future. And when the mother's cancer gets brought up, that's when the emotional stakes hit a different level. The judge is basically saying, if you're locked up, you won't be there when your family needs you. This is the kind of courtroom moment where the legal system meets real life. Consequences, empathy, fear, responsibility, all colliding at once. What do you think? Is the judge being too harsh or exactly right here?
It's not
Funny.
that, because it's not that.
It's not funny. It's what's next? An aggravated assault where you pull a gun on something, where you're looking at up to 20 years in prison? All it takes, the thing is, look at me. The thing is that, you don't get many chances in life, but to reflect and look at what you're doing and thinking to yourself, oh my God, if I do this, what's going to happen? If I say this, what's going to happen? Ma'am, think before you act. Sometimes.
Sorry.
That's when it hurts. If you can't look at me in the face, am I speaking truth?
She's angry because of her kids.
I'm not. She's what?
She's angry because of her kids.
Is this the proper response because mom has cancer? What if she really needs your help and you're in custody? Who's going to take care of mom? What kind of cancer do you have?
Okay.
What do you do for a living, ma'am?
I work for a radiology doctor and an oncology doctor.
Okay. Do you, are you married, ma'am?
No.
How many children do you have? I will appoint you a lawyer, but today it's already 1:00 and everybody's gone. We can give you an application. Come back to us in a couple weeks or whenever you want, and I can appoint you a lawyer. If you want to come back tomorrow, we can have you come back tomorrow and we can give you a lawyer tomorrow.
On Saturday?
Oh, tomorrow's Saturday. Hell no. I meant Monday. I'm not coming tomorrow. You cannot even drag me.
She's a good girl.
It's a second assault case.
The first one, can
It's
you explain to him that?
actions speak louder than words. What you tell me goes in one ear, goes out the other. Paper dictates.
You read it.
Well, I'm not going to read it. I'm just telling you what I see.
Because you see the word this is assault, you're assuming that it was my fault. That's why I said all you have to do is read it. This situation,
I don't want to talk about this case, but
your situation,
the problem is this case. And from what they've read, I will let you pick whatever day you want to come back. You can come back together, okay? The only thing I'm asking you, both of you guys, do not pick up any new cases. Do not get in any more fights. Don't drink alcohol, don't use any dope, and you'll be fine with me, okay? I will have you go to Victoria. You guys can pick whatever date you want to come back. Come back, bring the paperwork, come early, and then we can appoint your lawyers early. That way you don't have to wait this long as well.
Doctor's appointment on Monday.
Okay,
I can come back there, the first one is at 10:30 a.m., the second one is at 12 a.m. I can come right after that, it's at 12.
no, we're done usually, yeah, because lawyers are usually gone and out of here by 12:30. So, you can come Tuesday if you want early, you can come Wednesday, any day you want to come. You can come the following week too, if you want. So I'm not, you can come next week, you come the following week, whatever you want. I'm not, I'll give you up to, 30 days for you to decide what day you want to come back. My only concern is I don't want any more trouble. That's all. And I want our streets to be safe, Imagine Ms. Torres and Ms. Ortega, what if you had gotten out and the other person has a gun? Do you know how many cases we see here where people get shot because they get out with this road rage? I mean, look, the DA, he's shaking his head over there, man. How many cases we have? You just get out of the car, you start walking, another person's got a gun, they start shooting. Even to officers, it happens. Yeah. All right. Enough preaching. I'll have you guys go over there. You guys are gonna have to wait just a little bit for Tracy to get back. Once you sign your bond conditions, you guys are free to go. Okay?
I got a message to my phone saying I have to pick up a portable.
So maybe they were conditions from the magistrate.
Oh, perhaps the magistrate put like an
said it-
ankle monitor on you.
The paper that y'all gave me from right here, it says they're portable for my car. This the text message.
Torres,
Mhm.
just haven't taken note about any portable for.
Yeah, I know. It's gotta be perhaps from the magistrate. I don't know.
What's the case number on this case, so I can look it up?
251
251
7262.
7262.
I,
She put it on,
I don't see it.
what did she say, portable?
Judge, it says that on the general conditions of release and supervision.
You saw that, Ramona?
Yeah, Judge, it's on there, on her new case.
Where? I don't see it.
Is this Torres, Olivia Torres?
Yeah.
It's her general conditions of release and supervision,
From
right underneath her bond condition, her bond.
under that capias thing?
No, it's right under the capias.
It says if you're charged with the DWI. Second, install an ignition interlock.
So that's what she's talking about. And maybe it doesn't apply to this case, but
Yeah,
that's why she got that.
it doesn't apply here. I don't know. Tracy, can you see if this horse has been ordered to have an interlock? Do you need the cause number? I don't see it. Regardless, if they had ordered it on you, I will take it off. Just don't consume, don't use. They're going to call you to take a drug test or an alcohol test. And I am going to test you 31 days. Just as long as you don't use any dope, you'll be fine. And no alcohol. All right? All right. Go sign your resets. Okay, you can take it off.
And that wraps up one of the most emotionally charged road rage hearings we've seen. What started as a simple honk at a gate spiraled into physical violence, injuries, drug tests, bond conditions, and some very real warnings from a judge who clearly sees this pattern far too often. Both Ortega and Torres walked out with strict conditions: no drugs, no alcohol, no contact with the victims, and mandatory return dates for further testing and attorney assignments. The judge emphasized the same message repeatedly: think before you act. One reckless moment can ruin your life, or some